All right, well, welcome everyone. We are hosting today the Hiring Employees Farm Labor Law Basics Workshop, so hopefully you're in the right place. My name is Jennifer Hashley. I'm the director of the New Entry Sustainable Farming Project. And I'd love to invite you all to introduce yourselves in the chat. If you'd like to rename yourself, add your pronouns, where your farm name or organization name, maybe where you're calling in from today. And just ask everyone to keep yourself muted until the Q&A session, or as Rachel goes through the presentation, if she's asking for participation, obviously please unmute yourself and contribute. And if you have any questions, you're welcome to use the chat feature. I'll be monitoring that. But yeah, this is meant to be interactive and engaging, so hopefully everyone can participate and knows how to turn on and off their mute button. And we'll be recording this, so your video is optional, but if we're going to have a conversation, it's nice to have it on so we can see who we're talking to. So welcome. Again, I'm Jennifer with the New Entry Sustainable Farming Project. We're here in Eastern Massachusetts. Just a brief background, we're a beginning farmer training programs ourselves, and we are trying to help beginning farmers get started and help make their food accessible to everyone through a bunch of our different programs. We're here in Eastern Massachusetts on Pawtucket and Massachusetts people land, and you can check out where you're from or which native lands you're stewarding as well on the native-land.ca website. And some of our main programs are farmer training programs, which include all of our educational courses, crop production training, business planning, and our incubator farm program, where folks can access land for up to 3 years in a supported environment. We run a food hub, and then we do some national and regional capacity building programs with other incubator and apprenticeship programs across the country. So this particular project that we're working with partners on is a 3-year SARE Novel Approaches Research and Education project called Creative Farm Business Models to address employee hiring, training, and management barriers. So this has come about, as we all know, it's really challenging. There's a lot of challenges in finding and securing labor, and also addressing worker justice issues and paying fair wages and finding and retaining people and all the different challenges that we know about. So we wanted to build a project that would help address maybe some creative business models to address farm labor challenges. And we're doing this in partnership with Farm Commons, who's presenting today, and then worked with a lot of the Northeast Cooperative Extension land grant universities in the Northeast and New England to pull this together through the project. And a lot of the labor challenges that have been identified, many of you in your registration form for this workshop today reiterated many of these. For employers, finding and hiring is a challenge, where to advertise and recruit, the time to onboard and train folks, and what kind of skills do they have, especially if you're looking for a manager level experience, that can be potentially trickier to find sometimes. Being able to pay the wages that the market is commanding, the cost of living, is housing available, all of that. And making your own operations economically viable, and then having the reliability and the retention of those employees once you do find them. And from the other side of the workers, are they able to sustain their livelihoods with the wages they're receiving? The seasonality can be a challenge, housing, whether benefits are offered, the working conditions, is there opportunity for growth, and are they treated respectfully? Those are a lot of the things that we've heard as challenges in the sector. So through this project, our hypothesis was that maybe there's an alternative way of meeting everybody's needs, and can we look at some of these models and assess the feasibility and the producer acceptance of potential models. So we looked at 4 main models around collaborative business models, either worker owned or producer owned, maybe temporary farm labor businesses or other models like that. We gave a whole webinar presenting the outcomes and approach of this. So we developed these models, we did a bunch of focus groups, we generated a report, we developed some characteristics of a desired model, presented it again in focus groups in 2021, and then put that together in a report, and then issued a follow-up survey this spring, and really tried to dig into this entity X and to figure out what extent would it provide value to both owners and workers. And so if you would like to check out that webinar, I will put the link in the chat. It was recorded, and you're welcome to catch up with that if you didn't get a chance to participate or haven't seen the recording yet. But out of all of that project, one of the things we realized throughout was that there was a big need among farmers and workers to some degree about more labor and regulatory education for producers. It was a little challenging through some of the focus groups to really try to dive in on some of the details of these alternative models when it was clear that producers sometimes didn't have a full understanding of their obligations as employers or the requirements of the law. So we wanted to put together this session today so that we could help hopefully answer a lot of those questions and bring to light some of the obligations of employers related to farm employment law. So with that, I am happy to turn it over to Rachel Armstrong from Farm Commons to lead us through our session today. So thank you, Rachel.
All right. Good deal. Well, I am thrilled to be here with you today, folks. We'll be covering specifics for New England, New York, and beyond because we snuck in some bonus extra states into the webinar today. Now, that being said, if you're not from one of these states, no problem. You're still going to learn a ton about the basics of hiring employees, and we do have more state-specific information for all the states at our website. But who am I? Well, I am the executive director and founder of Farm Commons. I am an attorney, but practicing law is actually not what I do all day. It is this kind of thing. You'll find me in Duluth, Minnesota, where there is still snow on the ground. In the native language, Ojibwe-Moan, Duluth, Minnesota is called Misabakong, or the land of the giants. Good stuff. We have some great rock outcroppings that the belief is that it led to the land of the giants. So I founded Farm Commons because I believe farmers deserve this information so that you can develop resilience consistent with your values. And nowhere is that more important than when we're thinking about employment law. Living in a democracy, the idea goes that our laws reflect our collective values. So to the extent that the information you hear today does not reflect your values, that can be a call to action to motivate, to organize, to change those laws. And to the extent that they are consistent with those values, it's good motivation to see how you can comply. You are an important part of today's presentation. I love your questions. I welcome them. I encourage them. Please use that chat box to let me know what's on your mind as we move through today's presentation. Presentations on farm employment law are some of our bread and butter. I love doing them. It's good stuff. So don't hesitate to reach out and let me know what you're thinking about this content. A little bit more about the mission of Farm Commons. We empower agricultural communities to address their own legal vulnerabilities within an ecosystem of support. That ecosystem of support includes attorneys. Now, that being said, we really believe that those most affected by a problem are usually the best people to create the solution to the problem. That's farmers. So our work doesn't emphasize the use of attorneys except where they are necessary to help make sure that we can develop resilience. You'll see us write guides, do workshops like this, host webinars, podcasts. We have a question and answer platform, and we do leadership development. Membership does make it possible for us to provide our services. And a lot of what you'll find here today is for free in this context. But if you do want to go forward and look at this stuff on our website, it is available under our membership model. So like Jennifer said, this project, this webinar is birthed out of our Collaborative Labor Solutions project, which asks the question, could we solve our employment law challenges by working together? Jennifer told you a little bit more about Entity X, how it could propose a solution. But in getting feedback on whether it is a solution, we discovered, look, farmers often feel overwhelmed, confused when navigating employment law obligations, and that's affecting people's ability to reflect on collaborative solutions. If we don't know where our starting point is, how can we truly assess where we would want to go and what it would take to get there? So from that, we have the action point that we really should spend some time learning more about our basic employment law obligations. And then we can prioritize what is essential and take those action steps to get where we want to go. Action steps that are individual and collaborative in nature. Now, admittedly, we didn't anticipate this necessarily in the beginning of the project, but fortunately, we had some supplemental funding in place through Northeast Extension Risk Management Education. It was devoted to outreach on farm employment law issues. So this nested right in there really well, and because we had this research previously funded. So today I'm going to run through minimum wage, overtime, workers' compensation, payroll taxes, and meal and rest breaks. Now, if you're thinking, oh, I know minimum wage, you probably do. You probably have a really good starting point, but I think I've got some nuggets of surprise for you on all of these elements. I do think you're going to walk away from this webinar, no matter what position you are at in your farming journey, or whether you're a farm advocate and help others, with a lot of good information to help make that journey more smooth. So let's get right into it. And again, use that chat box as we go. I can talk a lot, I can talk fast, I can talk loud. I am looking. You jump right in there because your questions are important. Minimum wage, let's do it. Okay, here's the facts. Some farms nationwide are not required to pay at least the minimum wage to their employees under state or federal law. Kind of weird, kind of weird. And for a lot of folks, it's like, well, who cares? I mean, I couldn't hire anyone if I only offered the minimum wage. The labor supply and the market conditions necessitate that I'm paying twice as much as a minimum wage. And that is absolutely the case, certainly in New England, New York, but also nationwide. However, this topic is still extremely relevant because let's take a look at our intern and our apprentice arrangements. Many times we are structuring those as like a monthly salary kind of thing. And what's important to recognize is that minimum wage still applies in most intern and apprentice contexts. It also might be news to you to know that minimum wage usually applies to all volunteers as well, if they're volunteering for a for-profit business. Also still applies to most people who are working on a piecework or salary basis. So when that salary, when the hours per month or per week creep up and that salary stays the same, we start to run the risk of an issue here. So what is minimum wage? Who does and does not have to pay at least the minimum wage? Let's start talking state specifics, because that's what's going to help you move forward. Are you in Connecticut, New York, Rhode Island, or Washington, D.C.? Well, easy answer. Minimum wage is owed. No matter what, got to pay at least the minimum wage. Here we have them listed out for you. We listed New York through a range because it can be location specific. And that is a trend nationwide. Cities like San Francisco, they can have a minimum wage that's actually higher than the state minimum wage. So if you're in one of these 4 states, life is easy. Just pay at least this much. Now, if you're not in one of those states, life is a little bit harder. Let's see, Massachusetts and New Jersey. Minimum wage is always owed, no matter what, yes. But we got 2 minimum wages. We have the minimum wage for agricultural labor, and we have the non-agricultural minimum wage. And there's a lot of variation between these, especially in Massachusetts. New Jersey, we've got, they're bunching up between $11 and $13 an hour. So this becomes really important to understand which minimum wage applies. It's easy to say that, $8 an hour is the agricultural minimum wage. But what does that mean? That means that for agricultural labor, you can pay that rate. Okay, well, that implies the question, well, what is non-agricultural labor? So this is actually the purview of a complex and varied set of state and federal rules, plus cases, lawsuits that have been brought that interpret those rules. Plus, combine that with politically driven enforcement policies at all levels. And this is actually an extremely complicated question of what is non-agricultural labor. If you, for any reason, and this subject will come up over and over again today, if in your situation you need a specific and accurate opinion on whether or not a precise task is agricultural labor, you need an attorney. It's not, it's too complex actually to handle in most educational forums like this. But I can offer you a fallback assuming you don't have the big bucks to go pay an attorney, you can play it safe by assuming that non-agricultural labor includes things like agritourism, festivals, classes on the weekends, pizza trucks. It includes value-added production, so turning raspberries into jam, freezing whole tomatoes, hosting classes, hosting school groups, starting a preschool, food service events, again, back to that pizza night or something like that, on-farm dinners, non-agricultural labor. Also, if you're going to play it safe, you're going to assume that any direct market sales are non-agricultural. So this means even attending a farmer's market, marketing to chefs at a restaurant, delivering your CSA shares. So we don't have solid, clear direction from the state and federal government that these direct market sales are agricultural labor. And when we don't have solid and clear direction that they are agricultural labor, the safe way to go is assume that they're not. So to skip back to this slide here, let's say we're in New Jersey and we're like, oh, do I have to pay the $13 an hour or do I get to pay the $11.05? Well, what are we doing? If we're going to the farmer's market, gosh, we better say 13. And to put a finer point on that, is the employee in question for whom we're asking this question, do they go to the farmer's market? Do they perform non-agricultural labor? For any work week in which they perform non-agricultural labor, we have lost that exemption and we need to pay the non-agricultural rate. I see a question. What about sales at a farm stand on the property? We've heard in Massachusetts that even post-harvest activities may not be agricultural labor, washing, packing veggies in the pack house. Great question. Yes, there is case law nationwide and enforcement activities in Massachusetts that support the interpretation that post-harvest activities may not be agricultural labor. There's a lot of wiggly words in there, and well, I am an attorney, so I gotta balance my language. The safe thing to do is to assume that anyone who is, doing the vast majority of their work in post-harvest may be engaging in non-agricultural labor. Usually when that post-harvest work is mixed with harvest work or clearly agricultural labor, we're in safer territory because those post-harvest things are very directly related to purely agricultural stuff. It's when we start doing only post-harvest, like packing veggies in the pack house, that we start to think now we've become non-agriculture. And this we see on a federal basis nationwide. I can think of two cases immediately. One was a large Georgia farm that had a pack shed employees who were bagging onions, non-agricultural because they didn't have any role in the field. All they did was bag onions. Same in Texas, a similar kind of scenario where people were working in a warehouse and not agricultural. Okay. So, I touched on a couple of states, but we got some more to go. Delaware, Maine, New Hampshire, Pennsylvania, and West Virginia. In some instances, these are states where no minimum wage is owed for agricultural labor. That is because these states have adopted the federal 500-man-day exception or exemption allowed for agricultural labor. You know where I'm headed with that. So in these states, and only these states, don't listen if you were, if I already told you you had to pay minimum wage. In these states, minimum wage is not owed if the farm had fewer than 500 man days in any calendar quarter of the previous year, and of course, only agricultural labor is performed. The natural next question is, what is a man day? Great one. Let's talk. A man day is any day in which one person shows up to work for at least 1 hour. Two people show up to work, both work at least 1 hour, 2 man days. So we got some math to do. We have some math to do. How many people are coming? How long are they staying? How many at once? Do we exceed 500 man days in any calendar quarter of the previous year? Any time in which we exceed 500 man days in any calendar quarter of the previous year, we owe at least the minimum wage this year, even if we have more or less than that threshold. But once again, let's remind ourselves that this exception, this ability to not pay the minimum wage in these states depends on this being agricultural labor. So none of these other things are involved. To say that another way, if a person is assigning non-agricultural labor to farm employees in Delaware, Maine, New Hampshire, Pennsylvania, or West Virginia, well, you owe at least the federal minimum wage, no matter how large or small your farm is. If you're assigning non-agricultural labor, forget about that 500 man day thing, you just don't qualify. All right, got a question coming in. 40-hour overtime threshold. Ooh, you're right, that will come up later. Thank you for that question. I will hold on to it for our overtime section. Okay, and let me see, I had another question in here. Oh, this is a really good one. What would it take for us to pay people comfortably above the highest minimum wage across the board, that the minimum wage discussion is irrelevant and we can focus on worker well-being? Absolutely, absolutely. In the finest iteration of our future, all of this is irrelevant because nobody is in a position to be looking at paying minimum wage. That being said, I do think it is often irrelevant, even right now. This comes up the most when we're looking at volunteer scenarios. There is no volunteers on a for-profit farm. They need to be treated as employees for all purposes. So we do need to, who we might be thinking of as volunteers, we actually need to be thinking about the minimum wage. And same with folks who are on a piecework basis or something like that. These rules are enforced even in the instance where everyone is happy. Everyone is happy to volunteer. Everyone is happy to have a monthly pay rate and then to watch those hours go way up and then go way down. Everyone's happy, but that's not, the law doesn't say, but only if people are upset. It's like, this is the law anyways. So we can have scenarios where people are quite content with what is going on, but it's still not compliant. Okay, so let's say you're in one of these states where you are taking advantage of a minimum wage exception. Maybe because you have a volunteer program, everyone is happy, and you're complying with the law by, even though you have employees who are volunteers, you still don't have to pay them the minimum wage. So in that case, you need to keep accurate records of exactly who was working each day, how long they worked, and what they did, so that you can prove that what was performed was agricultural labor. And then if we're basing this on our federal exemption, we are recalculating that exemption every year, those 500 man days. So in this instance, if we have a volunteer program that we've realized is actually employment for the purposes of employment law, but we have a minimum wage exemption, we can still conduct that program without violating these laws. Since I opened the Pandora's box of volunteers, we have some questions coming in, which is good. Is it legal to offer working shares such that volunteers get compensated in vegetables? Is that a gray area or flat out illegal? It's complicated. There are definitely viable opportunities to offer a volunteer program where folks are compensated in product. We have to go into a program like that knowing that the law sees this as employment, and we need to pay attention to our employment law obligations. That being said, it is not impossible to comply with employment laws with a working share program. So the value of the vegetables provided may meet the minimum wage. The minimum wage may not be required in that instance. So we can still we can still structure that. Now we got to go through all of our employment law obligations like overtime, workers' compensation, non-discrimination, all that good stuff. But I absolutely know farms that have looked at all of their employment law obligations for a worker share program, come out the other side and said, I think I'm in a good spot. Another question, how about it as a nonprofit? The landscape changes with a nonprofit. Nonprofits are allowed to have volunteers. So this is really about for-profit operations. For all the details, we do have a long 40-page guide at our website, Managing the Legal Risks of Intern and Volunteer Programs, that does go in depth. We also have a detailed in-kind wage guide. That's what it's called when you pay people in vegetables, in-kind wages, detailed guide on exactly what is required for those. Okay. But wait, what about you Marylanders and Vermonters? Well, you got to get your own slide because it's more complicated. Maryland does adopt the 500-man day exemption, but then when that's crossed, then we have some more delicate questions to ask. Well, I guess they're not delicate, they're just more questions to ask about then what minimum wage do you owe? So, little guidelines here. I have a handout. This stuff is complicated. And so in the instance that this is really important to you, you're in Maryland, we have a handout that we'll supply to all the attendees to help iron this out. So same with Vermont, there is an agricultural labor exemption more completely, but federal law still applies. But then we have to figure out, okay, do we owe the federal minimum wage or do we owe the Vermont minimum wage and when? Okay, so in the interest of time, we're going to leave the minimum wage issue there. And it can be helpful to really center on, is this an issue for you at all? Do you have some of these unpaid work positions in your operation where you might need to deal with this? Great question coming in concerning accurate records. How long are we required to keep time cards, pay stubs, and W-4s? I'll admit that is a state-specific determination that I didn't prepare for the purposes of this webinar. A good general guideline is 7 years. You're going to cover most of your obligations with that, but I shouldn't speak out of turn because I did not prepare that for this presentation. Let's talk overtime. Overtime, all right. A lot of the states in our region, Connecticut, Delaware, Maine, Massachusetts, New Hampshire, Rhode Island, New Jersey, Vermont, West Virginia. Are you assigning non-agricultural labor? No? No overtime. We'll delete that part because it's fallen. If no, then no overtime is owed. If yes, regular old rule applies, time and a half for all hours worked over 40. So this is somewhat cleaner in break here. We just go right to that. Is it non-agricultural labor? And then we have to go back to that definition. Or are you doing direct market sales? You do engaging in agritourism? The safe way to go is to assume that that is non-agricultural labor, and you do owe overtime for all hours worked over 40 in the week. Most folks know that there's something about a salary-based exemption to that. If your mind is going in that direction, you are not wrong. There is the possibility to avoid paying overtime if two conditions are met. First, their salary needs to be at least in the realm of $38,000 per year on an annual pay basis. That's often not that challenging, and a lot of farms will cross that threshold. The much more challenging factor is that this needs to be a management position. Management is best indicated by the fact that they have someone who works under them. It is not the only way to show that they are in a management position, but it is the best way. So if you have an employee who makes $33,000 annually, you've got to be worried. The salary exemption is not going to work for you. If you have someone that doesn't supervise anyone, just a field hand, you got to be worried again. This might not work for you. So in those cases, pay overtime. But again, states were left out. DC, well, pay overtime. New York is a little complicated. I'm going to give you the initial rule of overtime for all hours worked over 60, also for Maryland, but that situation is in flux. I can't say that enough. We're going to keep our eye on New York to see where things are going, because they keep changing their mind. Pennsylvania has some special overtime rules for seasonal and temporary workers. Now, if you are in a state that does not require overtime for agricultural workers on any threshold, this is a good time to say that the trends are changing nationwide. This has been in place since the dawn of overtime in America, that agricultural workers were not covered, but that is starting to change. We are seeing states fairly rapidly adopt overtime rules that apply to agricultural workers. Some of those are starting at very high thresholds, like 60 hours a week, but some of them, like Colorado, Washington, are coming in at the standard 40 hours a week, California. So this is something to keep one's eye on. And the resilient farm over time will be thinking about overtime. We'll be thinking about how to build this into the business model. How do we make sure that we have the profitability and the cash flow to provide time and a half, and or how do we ensure that no one works more than 40 hours a week? Okay. So that covers our minimum wage and overtime issues. To simplify things for you, to make things as easy as possible, pay at least the minimum wage, and pay at least the minimum wage for your state for non-agricultural labor. Then you don't have to worry. You don't have to worry if there are or are not ag rules and what they are. Just pay the same minimum wage that the coffee shop pays, and you'll be fine. You want to make things simple with overtime? Just pay it for all hours worked over 40. You don't have to worry, is this agricultural, non-agricultural? What's my threshold? Follow the rules again that the coffee shop follows, and you'll be fine. It's really if that's not possible for you, if your profitability or cash flow is challenging enough that your farm isn't viable without these exemptions. And then in that case, things get complicated. Then yes, you do have to wade through some complex rules. Dare I say, it's not supposed to be easy. It's not supposed to be easy to not pay the minimum wage or to not pay overtime. And there's a variety of rules that are complex and laden with a lot of issues, why these exceptions have been extended to agriculture over time. But the law does have a principle that it's not supposed to be easy to do this if you're an exception. Exceptions create challenges. So you know, it's hard to come with really positive news for those that do need these exceptions. And sometimes our best efforts are put towards developing the profitability and the cash flow to be able to meet the regular rules so we don't have to worry. All right. Workers' compensation. So workers' compensation, we're actually going to start with some of the background on why workers' compensation exists. Now, I do this because what I'm going to be telling you about is the value of workers' compensation to you. Because soon enough, we'll talk about the cost. And the cost, well, we have to look at why we have this. Most folks think of workers' compensation as a benefit for the employee. It was never designed to be a benefit to the employee. Workers' compensation was designed for the employer. So that's, I bring that up because most of you here are employers. And so I want you to know right away that buying workers' compensation was intended to protect you. So let's talk about back in the day before workers' compensation. Now, before workers' compensation was created, workers would get injured on the job. You know, this is a thing that happens in most all industries. People get hurt. When they get hurt, they sue their employers for those injuries. They say, hey, employer, this is unsafe working conditions. I will sue you. Hey, employer, you did a terrible job of training my colleague who then hurt me, you know? So there's a number of different arguments that folks can make to say, you provided unsafe tools. This knife wasn't sharp enough. And that's what folks did. And then employers got in trouble because those conditions were unsafe. That person was untrained. Now, employers, this was not fun for them. This was unpredictable. When they would get sued, they would have to go to court to defend themselves and say, oh, come on, no, look, the knife was sharp enough. I did have a good training program. So they have to argue and defend themselves. And then they had no idea what the final liability would be. What would be the value? Or this person going to get, $50,000 for the broken leg or $1 million for the broken leg? So employers did not like this unpredictability, and thus the workers' compensation program. So Wisconsin was the first state in 1911 to pass a workers' compensation law, and then this built up some steam before every state had it by 1948. Workers' compensation eliminated the unpredictability of these lawsuits. Employees who are covered under a workers' compensation policy cannot sue their employer for their injuries. The only recourse that a person covered by workers' compensation has is the workers' compensation system. This is called a no-fault system. That means we don't care whose fault it is. Was it the employee's fault because they didn't follow the procedure? Was it the employer's fault for not training them well enough? We don't even ask those questions. We just use the workers' compensation system to make folks whole. So this is a different method of getting compensated. We're not using the court system, we're using the workers' comp system. What does it matter? Well, it's not going to hinge on wrongdoing anymore. Oh, sorry. These are a little too detailed, and I want to make a little more time. So we use the workers' compensation system instead. It's a different process. You simply make a claim. The injured individual just goes to the workers' compensation system and says, hey, I was injured. Okay, as long as it was incurred in the course of employment, you get the funds. It's predictable. The employer knows exactly what they are going to pay for the workers' comp policy. So they're not going to be dealing with these unpredictable judgments or difficult process or be defending themselves in court. All right. Now, this sounds a little bad because, well, wait, all the accountability on the employer went away. Employers now, if we're not talking about whether or not the employee's training system was bad, where's their accountability? OSHA. Occupational Safety and Health Administration is a federal office, and in each state, OSHA is now the protector of workplace safety. OSHA sets standards for what are appropriate training programs, what tools are safe. People tend to think of it in like rules about railings. You got to put up railings in certain places so people don't fall over the edge, tractor rollover bars, all of that good stuff that protects employees from injury. OSHA is now the avenue for determining whether or not a workplace is safe, and non-compliance with OSHA will come with some big fat fines. But as it says on the slide, well, unless the employer is a small family farm operation. Technically, OSHA also applies to all farms, regardless of their size in America, federal OSHA. And so technically, the obligation to have tractor rollover bars, safe working conditions and good training programs and all of the rest does apply to every farm in America. But, every year since forever, Congress has prohibited OSHA, the administration, from spending any money to enforce OSHA against a farm with 10 or fewer employees who does not also operate a labor camp, who doesn't house anyone on their property. So there is actually very little accountability for workplace safety on farms. OSHA can't enforce their laws, workers can't sue. So it's really incumbent on farmers themselves to create safe work conditions and explore what OSHA requires and meet them, because technically they are required to meet them. It's just that the administration is prohibited from enforcing it. So this is how we've gotten to the situation we are at, where workers' compensation is the key way to compensate those who are injured on the job. Workers' compensation can be valuable to the employee as well, because not only does it cover medical bills, it covers lost wages for the time that they are unable to work. It can also provide mileage to doctor visits and benefits in the form of flat fees, compensation provided for like loss of a digit, loss of sight, those sorts of things. So it does try to capture what may have been, some of the benefits that were awarded previously through the lawsuit-based system. And it follows a similar pattern to an insurance company. The injured worker makes a claim. The workers' comp folks investigate the claim to confirm that it was incurred in the course of employment, and then those payments are made. But this costs you money to participate in this system as an employer, of course. And the total cost to get a workers' comp policy are dependent on three things. Number one is your total payroll. When total payroll is low, your premium is low. And that's because the payout to the worker for lost wages will be lower. But number two, the risk classification of the work activities. That's a big factor. And the more dangerous the work you assign, the more your workers' comp premium will go up. Risky things are, of course, anything with PTO units, chainsaws, ladders, those sorts of things. And then anytime a claim is filed, anytime a worker suffers an injury, your premium goes up, because there is concern that the workplace is not as safe as it could or should be. So yeah, great question, Jennifer. Your insurance rating, as they call it, which is that third factor, does change, and thus the premium increases if you've come through with a lot of claims. This can be awkward. It can create some pressure on those who are entitled to file a claim to not file a claim, because it will lead to a higher premium for the farm operation. So there's a lot of complexity that ends up getting tied into what is supposed to be a straightforward solution. So do you need to buy workers' comp? I mean, that's the threshold question. Each state has its own program, and sometimes there are agricultural exemptions. So we will explore those. Connecticut, Massachusetts, New Hampshire, New Jersey, New York, and Washington, D.C. Workers' compensation is required. Simple. Straightforward. You got to get it. But then we got our other states. Delaware, well, I guess it's also easy. Workers' compensation is not required for agricultural labor. And the other states are a little more complicated. Maine, Maryland, Pennsylvania, Rhode Island, Vermont, West Virginia. Workers' compensation is required for agricultural labor when certain thresholds are met. Our handout will outline those for you specifically. Let me give you some examples. Maryland, farm and ranch businesses have to purchase workers' compensation when the business has 3 or more full-time employees or an annual payroll of 15,000 or more. And that's a very common formula. It usually has to do with your total payroll and how many people you employed. The Maryland 3 or more and 15,000 is fairly on the high end. A state like Pennsylvania, they go a lot lower. And as soon as you pay 1,200 in wages, you cross the line. Again, we can make this easy. We can make this simple. You can just buy workers' compensation. Then you know whether you have to or not, you've done it. And you can also gain that peace of mind that nobody can sue you for injuries that they have incurred in the course of employment. So that is definitely the safe way to go if you can swing it financially. If you are not required to buy workers' compensation, you now know you are exposed to the risk of lawsuits. If someone on the farm is injured, they can sue you. So you'll still need some insurance for that, because that could really, that could hurt in a hurry. So what you got to do in that case is go to a traditional liability insurance provider and say, look, I need coverage for my employees. And usually they'll say, what do you mean buy workers' comp? And you'll say, no, I'm a farm. I don't have to buy workers' comp. And they'll say, oh, well, okay, then we, in that rare case where we have a farm who doesn't have to pay workers' comp, we have this policy over here. No one ever buys it. And, we don't know a lot about it. And, so it can be hard to find and expensive because there is such a small market for this. All right, so that's what I've got for you on workers' compensation. Again, it's people see it as expensive, but I want to be sure you know what the value of it is, so that you can make that assessment for yourself on whether it's worth it. All right, we got a little bit on payroll to bring us to our final question and answer section. Payroll taxes come in a few different forms. FICA, which is Medicare and Social Security, unemployment, and then our obligation to withhold income tax and remit that to the state. So how do we do this? Well, first, once again, we have to keep in mind that this ag versus non-agricultural work comes into play again for our payroll obligations. So I'm going to walk you through that. FICA, this is Social Security and Medicare. These are the federal rules because, they collect FICA. For agricultural work, we're required to pay into the system once we pay wages of $150 to any employee or $2,500 total to all employees. Anyone who's paying someone to get work done on the farm is probably going to cross that threshold pretty soon. So it's worth it to just start accounting for it right away. And if you're assigning non-ag work, well, it's payable as soon as any wages are paid. What about unemployment? So the federal threshold is that you don't owe unemployment tax until you have paid $20,000 in wages in any calendar quarter of this or the previous year, or you've had 10 employees for at least 20 weeks. Now that the precise articulation is a bit more complicated, but I've summarized it for you there. If you are anywhere near this threshold, you need to do a little bit more research to make sure you know exactly when you'll cross that threshold. Now, there is also state unemployment tax. The feds will collect it and the state will also collect it. And most states copy the same federal threshold for agricultural labor. And I've got that list for you here. Rhode Island, though, kicks in right away and requires nearly all employees to pay into the state system, and Washington, D.C. Does as well. Let's talk unemployment. I'm wrapping up quickly here, so hang on with me through the rest of these annoying details. We need to start withholding our employees' pay when our total payroll equals $1,000, and state thresholds vary. Again, kind of the easiest route to take is just start doing the withholding right away, and you don't have to fuss about it. So again, we have these very minor thresholds that come in for our federal and state income tax withholding. Again, you can simply pay the taxes on all the work, no matter what type, to make your life easier. Then you can assign, variable labor to individuals, and knowing that you are covered. If you're taking advantage of the agricultural exemptions, pay attention to the rules. Another way to avoid the complexity and scariness of farm employment rules around payroll taxes is to hire a payroll service that has experience with agricultural businesses. They will, as part of their service to you, keep track of when you have crossed certain thresholds, when you are now obligated to pay into specific programs, and make sure that that happens for you automatically. So again, you probably already know about payroll services, and you know that they charge a fee for the service that they perform, but it can be worth it. If you don't like plowing through these rules, shop around, see what the various payroll providers will charge you per month for your employees, and see if that's worth you not having to learn these rules. One more slide on meal and rest breaks. They are generally not required, but we do want folks in Connecticut, Maine, New Hampshire, Rhode Island, New York, Vermont, and West Virginia to know that at some points, yes, you are required to provide a meal break and specific rest breaks to folks. Details in our handout if you feel that might be an issue for you. So action steps, what can we do to move forward? Keep an eye out for these handouts that we'll send you afterwards, which will help you reabsorb the details specific to your state. And in our handouts, they're state specific. So if you're in, New Hampshire, you don't have to get distracted by Maine. You can focus. So look for that. The feasibility guide, of course, also covers the other material that we that was a part of this program. So what are the collaborative labor solutions that are open to us? So take a look, again, in your email after this presentation, take a look for the feasibility guide coming out, and probably it'll be, well, I'm not exactly sure, but I know in a few months, it'll be done. So, so look for that. If you've been inspired to dig in deep today on your farm employment law obligations, I do have some additional resources at the Farm Commons website that I can recommend. If you're in a state that was not one that we discussed for this presentation, again, we have these same basics for every state in the union. You can also register for our Discovering Resilience course. During the summer, it's strictly a self-paced course. You can take it in your own time, learn the 10 basics of a legally resilient farm. And if you only want to know about farm employment law, we got you covered there too. A 5-module course, all on farm employment law. We get into in-kind wages, classification. What about independent contractors? More details than you might think you want right now, but I think you'll enjoy. You can take that course at any time, starting right away if you want at our website. All right. So we got time left for questions. What's rolling in here? Oh, good comment. All right. State set workers' comp rates. So theoretically, you don't have to shop around for the best deal. And yes, that's definitely true. It's unlikely that someone will offer you a different rate because these things are all set by formula. Where things get a little squishy is what's the risk category that your business has been assigned. So sometimes if your insurance agent doesn't take a thorough inquiry into what you're doing, they might be like, oh, well, that's farm work. They're probably driving tractors, there's probably some chainsaws, and you end up with this higher risk classification. You can always go back to the person who worked with you on the policy and say, no, this is hand labor only. There are no horses on this operation. There are no livestock on this operation. So you can see if there's a lesser risk category that you would fall into. But bear in mind, if you, for one day, have that individual use a tractor and they fall off, you didn't have coverage for that because you weren't in the right risk classification. You didn't tell the agent, well, yeah, they'll get on a tractor once. Once they get on a tractor once, you got to pay for that.
I'll just add to Rachel, the first time we had workers' comp insurance for the first few years at our farm, my personal farm, not the new entry farm, we had a risk workers' comp auditor come to the farm every year and ask to look and pull our payroll records, and they kind of did their own audit to figure out what we were having people do. So it wasn't like I just signed up for insurance and that was the end of it. Like a physical human being came and sat next to me at my desk and asked me to pull payroll statements from certain weeks of the year and like look through records. And I wasn't expecting that. So just, I don't know if other people have had a similar experience, but they were serious about taking their workers' comp auditing responsibilities seriously.
No, I'm glad you brought that up. That's very true. When you add employees in the middle of the year, it's not like buying a tractor and then calling your insurance company and saying, "Oh, I have a new tractor." You don't really have to call because they'll audit you at the end of the year. How much payroll did you actually pay? Oh, looks like your premium, your premium should have gone up, so now you need to pay us some extra money at the end of the year. So it's predictability at the beginning of the year if your payroll doesn't vary from what you told them, but they'll look back retroactively and say, "Oh, I see your payroll's a little higher than you told us, and now we'd like more money." Farm Commons pays into workers' compensation, and I've never had an in-person audit. That would be more intimidating, but every year I have to submit a lot of payroll records. Any other thoughts or questions? Are there requirements for how often workers need to be paid? Great question. There are. They are state specific for the most part, and I'll admit I did not prepare those for today's presentation. These are less likely to vary by agricultural and not agricultural labor. A general rule across the states is at least once every month, workers need to be paid. Oh, okay. Someone wants clarification around the management positions and salary exemptions. Okay. So to take that from the top, using a salary strategy, using a salary is one key way that many businesses across America in all industries manage their overtime obligations. The law says that if you pay someone at least, and the number changes, I'm not exactly sure, but it's about $37,000. If you pay someone at least $37,000 annually for their work and they are in a management position, primarily indicated by the fact that they supervise someone else, if those two conditions are met, you can salary them and then not pay them overtime for all hours worked over 40. That salary does mean in weeks in which they don't work, you still pay them. So it can't just be, "I'll pay you this salary when you work." It needs to be, "I'm always paying you this rate." Sometimes those numbers go up, sometimes those numbers go down. Let me know if any more clarification needed there.
Folks are also welcome to unmute and ask a question verbally into the room if you'd like as well. We're a small group, so feel free to unmute or raise your hand and ask your question directly. And someone did ask, will there be a copy of the recording sent out afterward? Yes, there will be. We'll definitely send the link to the recording. And if there are no more questions, I do have a couple other slides about next steps and wanted just to mention a bunch of agricultural resources that we will be sending out afterward as well. But I still want to make sure folks can ask the questions that they have. And I see that Liz Henderson, I know you're here from the Agricultural Justice Project, and you've been working really hard to elevate the standards for workers throughout the country through the project. I don't know if you want to say a few words about the work that you're doing so that other folks know that they can get in touch with you or reach out if they'd like to apply for certification with your program. All right, well, I'm happy to share my screen and share some other resources. And Liz, if you are able to participate and say a few words, you're welcome to just interrupt. So I have a couple of quick poll questions that I'd love to ask folks as well. We are, as I said, this is supported by the SARE, Sustainable Ag and Research and Education Grant. So we'd love to have a quick evaluation. There's 2 questions here. Hopefully folks can see that while I'm getting the slideshow up and running. But there's 2 questions. If you could just rate your knowledge and understanding of farm legal issues before the workshop and after the workshop, that would be appreciated while I share the other slides. Just wanted to say a few next steps. Can you see the evaluation questions, Rachel? I just want to make sure. Okay, great. So for next steps, as Rachel mentioned, there are some worksheets and resources that will be that Farm Commons has developed, and we'll make sure that those are available and circulated as well with our report, and a short decision guide about some of the models that we've looked at, and the final report and recommendations for this project will be shared as well. We're in the process of starting to analyze the survey that will go into the final report. So once that is all wrapped up and finalized this summer, we will be posting that, and it will be on the SARE website that I put in the link earlier so folks can follow along. If you'd like to test these models or do similar work in your region, you'll find everything that we've developed through this project on this site. You're welcome to look at it and make it your own, because this is obviously something that we'd love to see more of. And if you come up with other alternative creative models that work in your area or can be adapted, we'd love to learn about it and share that out as well. So definitely this is open source, and hope everybody takes away what they can from the work that we've done in this project. I will send around this list by email, but there's a lot of great resources available. Obviously, Farm Commons has done tremendous work in this area. Even the Department of Labor has a pretty straightforward compliance toolkit that you can review and understand what your obligations are. Cornell has done many projects around employee training resources and standard operating procedures, and has farming guides. New Entry, we've put together a library of farm labor resources and have YouTube videos on these topics, and we've done a lot of projects with the Legal Food Hub here in Massachusetts around farm employment law. So those links will send that to you. UConn has a short resource list, and then UVM has done a lot of research work and has a great farm labor dashboard, and Liz dropped that in the chat earlier. So there's a lot of tools, resources, and workshops, and some still happening here in April. If you didn't get enough today, there's more opportunities to continue to learn. As Rachel mentioned, there's the wonderful workshop that they are offering as well. So we'll send these out in the follow-up email. We will post the recording from today on New Entry's YouTube channel under our Farmer Resources section playlist, as you will, and I dropped that link into the chat earlier as well to find that. And I just wanted to thank SARE, thank all the farmers and the workers who engaged in our focus groups for this project and really helped shape what we accomplished and what we offered today. And just to thank so much Rachel and her team at Farm Commons and all of our partners for all the amazing work that they put into developing the focus group formats and questions and synthesizing the results and writing up the reports and offering and being our legal beacon so that we can all better understand the risks. So thank you so much. And again, we can hang out for a little bit and answer any other questions that folks have, or feel free to follow up directly with us so that you can continue to answer your questions and manage your legal risks. So I'll stop sharing and open it back up for questions. All right. Well, I think we can close out today then. Thank you all so much. And thank you, Rachel. Appreciate it.
Thanks, everyone. Yep.